The next case is State of Ohio versus Thomas A. Petersen. Each party will have 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know as I will be keeping the time. The arguments are being recorded. Please keep your voice up and remain behind the podium. You should not use the name of children, minors, and victims during your argument. You can refer to them by initials or terms like the child. The judges have read your briefs and are ready to proceed.
Good morning, Your Honors. Attorney Eric Hall here on behalf of the appellant Thomas A. Petersen. I'd like to just kind of split my argument, roughly 7 minutes, and then reserve the rest for rebuttal.
You can only reserve up to 5 minutes. You can only reserve up to 5 minutes.
Oh, I'm sorry, Your Honor. And then I will take 10 minutes and reserve 5 minutes, Your Honors. Thank you. Thank you. Your Honors, the facts in this case, the appellant was involved in a single car accident. An Ohio State Highway Patrol trooper arrived at the scene. The appellant was in the vehicle. Initially, he was awake. Then he became unresponsive. The EMT arrived. Narcan was administered, okay, and the appellant became a little more responsive. In this case, as a result of the accident, and back to the trooper's opinion, he was charged with 2 counts, 1 count of OBI, driving under the influence of drugs or alcohol, and the other was a minor misdemeanor Mark Lane's violation. Case proceeded to a jury trial. The jury came back with a verdict, guilty on both counts. 2 assignments of error, Your Honor, both based upon the evidence case. One, there was insufficient evidence presented in the trial to find the appellant guilty of OBI. Also, the conviction was against the manifest weight of the evidence, and I'll tell you there's reasons why. There's a complete lack of evidence in this case, other than the accident and the fact that the appellant was unresponsive. The appellant believed he had a seizure. As a matter of fact, there was a call, I believe it was a 911 call, which indicated initially that the person in the car had suffered a seizure. So that was the information that the trooper had before they got to the scene, was that there was a seizure-related incident. The search of the vehicle produced no drugs, no drug paraphernalia. The appellant did not take any tests. Did not take a breath test, did not take a urine test. So the trooper's opinion in this case was based upon some of his observations, and I would point out to the court that he's not medically trained.
Can I ask you some questions about the trooper, the evidence? Did he testify that he was trained in drug detection?
That's true, Your Honor. He did testify to that. He did indicate during the trial some of the indicators that he believed would raise a suspicion of somebody being under the influence of drug use or alcohol use.
And did he opine specifically which drug he believed the defendant was impaired by?
He believed it was an opioid, Your Honor, some type of opioid. That was based upon his opinion. He said glue, clammy skin, he pinpointed pupils, and some other things. There was also some testimony that they believed that there were marks on the appellant's arms that were track marks from intravenous drug use. But what I would say that none of these things were, although they were presented as observations, none of these things were actually supported by any kind of expert or medical testimony. And there was an EMT person that was trained that was on the scene. He also gave the opinion that based upon his experience that this was due to some type of drug overdose of opioid. But again, none of these individuals, and I don't want to diminish the experience of the EMT person, but they're not a doctor, and there's really no diagnosis made. This was an on-scene, this opinion was developed based upon some observations that were made on scene at the time.
I don't recall, were there objections made during the trial to these folks testifying as to their opinion?
I believe defense counsel made it a point with the jury to point out that the EMT person was not a doctor.
Well, but when they were testifying, did they object to them rendering an opinion? I appreciate they argued, these aren't medical professionals, and I know they did that, but did they object at the time?
I'm going from memory here, I'm not sure, but I believe that they probably did because of the amount of focus on with the jury indicating that the person, that neither of these people, and especially the focus on the EMT person, that they were not a doctor. And that was, I think that was emphasized more than once in the trial, that the opinion, these were just opinions, and neither of these opinions were the opinions of a doctor. Okay, someone who's trained and could make a diagnosis.
And so the, that was said at trial, so that was heard at trial, that they,
Oh, yes, Your Honor, both the trooper and the EMT person both testified that it was their opinion that the appellant was under the influence of some type of opioid. Well, again, there's no test results that would support that. Other than the crash itself, there was no observation of any driving. Okay, so if the trooper arrived at the scene and just saw a crashed car, which there could be a lot of explanations for that. The appellant indicated that he had suffered a seizure. I read the brief filed by the state that said he had a seizure when he was I believe a teenager. But the fact that he had a seizure, I mean, once again, I don't think that was ruled out in a trial by any type of medical testimony.
and counsel, did the EMT testify not only about his experience in dealing with people and treating people who had been on drugs of abuse, but also in dealing with people who might be having seizures?
Well, yes, and I think there was some testimony to that effect, that he indicated that some of the things that he thought are in his opinion, the appellant did not show signs of some of these characteristics of the seizure. Once again, without a medical expert, I don't know that what he testified to the argument, whether that was all inclusive or not. Once again, it was the opinion of somebody who is medically trained to a certain level of degree, but not the same level as a doctor or physician. So that was one of the weaknesses in this case, which I thought that the jury focused too much on the opinions of these two individuals, and without looking at, I mean, there was a complete lack of evidence as far as any type of physical evidence that would connect him with drugs or alcohol. In the car, the car was searched, and usually somebody who uses intravenous drugs, it's of course probably aware, there's always some kind of sign of paraphernalia or other types of drugs or containers that may have held drugs. None of that was found in his car. So again, I think that the jury lost its way. I mean, they gave a lot of credit and to the credibility to the trooper, and that happens a lot in these type of cases, and also to the other individual, the EMT person. But once again, a complete lack of evidence in this case, no test results, which obviously would have indicated one way or the other, either the appellant was in fact under the influence of an opioid or was not. That's not there for the jury to see. There were no witnesses, I believe, to the appellant's driving to what caused the accident. As far as the accident itself, I don't believe the appellant was injured, but when the trooper arrived, he was awake, and then he became unresponsive, and then of course he was Narcan. I don't see, sorry, it's going to be the Narcan was an indication that he was under the influence of an opioid and an overdose. But I would argue to the court that Narcan is not an accepted test, okay, a medical test to determine whether somebody's under the influence. I mean, it's a treatment. I guess an emergency treatment for somebody who may have overdosed on an opioid or some other similar type of substance. But again, it's not an accepted test for opioid ingestion. There are other tests, the urine test, blood test, would prove those things. In this case, none of those were done. Again, I think the jury lost its way in this case, both the weight of the evidence and the sufficiency of the evidence, and I would ask the court to reverse this conviction. You don't have any other questions?
Any other questions?
Thank you.
Good morning. Excuse me. May it please the court, my name is Megan Philbin. I represent the appellee of the state of Ohio in this appeal. I am a prosecutor for the city of Medina. I was the prosecutor who tried the original case to the jury here. So this appeal arose after Mr. Petersen was found guilty of operating a vehicle while under the influence of drug abuse, specifically under Ohio Revised Code 4511-19A1A.
So we do have the two assignments of error. I'm gonna go in order, but they're gonna kind of mesh together because sufficiency of evidence and manifest weight, there's some of the same overlap of the facts of the case. So, so initially, Mr. Petersen argues that there was insufficient evidence that was presented at the jury trial to convict him of OVI in this case, and the state disagrees. So the standard for sufficiency of evidence is to examine the evidence that's submitted at trial, determine whether such evidence, if believed, would have convinced the average mind of defendant's guilt beyond a reasonable doubt. So whether after viewing evidence in light most favor to the prosecution, any rational trier of fact could have found the essential elements proven beyond a reasonable doubt. So for sufficiency, it's whether the state has met its burden of production. So here, the state presented evidence in the form of 3 witness testimony and the body camera footage from Trooper Eaton. So the state called 3 witnesses. I'm going to designate the third party witness as JN because I think in OVIs they are considered the victims when they're involved in the crash. So JN was the third party witness. She was involved in the crash. We have Trooper Eaton from the Ohio State Highway Patrol also testified. He was the trooper that responded to the scene. We also had EMT and paramedic Jake Conaball testify as well. So the first witness that state called was JN, and she testified that she was operating her vehicle on 71 South when Mr. Petersen crossed all lanes of travel. So he was in the fast lane, I believe she was in the slow lane. He crossed all lanes of travel and hit into the side of her van. So we have a witness that did testify that they saw the operation of Mr. Petersen, and as soon as she was hit by Mr. Petersen, she spun out of control, I believe 2 times, came to a stop on the side of the road, and Mr. Petersen had stopped as well. She approached Mr. Petersen's vehicle and called out to him, and he was not responsive to her. She testified that Mr. Petersen appeared slumped over. He was not shaking. He was completely still. He was not moving. She stayed at the scene, and she also spoke with the trooper. The trooper responded. Trooper Eaton testified that he arrived at the crash, and he also approached Mr. Petersen's vehicle that was crashed off the side of the roadway. And when he viewed Mr. Petersen, he was leaned back in his seat. He was holding the steering wheel with one hand and holding his other hand in the air, kind of in a frozen position. And he was chewing gum and just staring straight ahead. Now,
Can I stop you just for a moment to ask, same question, using the right term. Was the trooper, did he testify that he was a drug recognition expert?
no, he did not. He is not a DRE.
So he's not, but he testified about, he basically, without being a DRE, testified about what drug he thought he was under the influence of?
So he testified to his training and his experience and what he believed that Mr. Petersen was under.
Is that good enough under the law when we have no tests?
Well, so we did not just have his testimony. We have also the testimony of the EMT paramedic.
And the EMT testified about what qualifications to know if somebody's under the influence of
Well, so
an
it's
opiate
both,
specifically?
yes, it's both his training and experience, and he indicated that that he did have the training to be able to identify that somebody was going through an opioid overdose, and also what he was to do in response to that. And
The training, what training? Like just EMT training?
EMT and paramedics. So he designated the difference between that training. I think one is a shorter program, one is more extensive and deals with more of the medical side of things.
If you didn't, do you think you would have sufficient evidence here if you didn't have the EMT testify? Because we have case law that says you have to be a DRE expert in order for the evidence to be sufficient, correct?
So I think it depends on the officer and their training experience. So specifically, I would say in this particular case with this trooper, there's a probability that would not have been enough. But with the EMT paramedic, his training experience definitively established the proof beyond a reasonable doubt in this case.
The officer testified he had some training, but not the drug recognition training, is that correct?
Yes, that's correct. So I believe his basic training, he indicated in his basic training that he's taught to notice the signs of impairment by a drug abuse. Specifically, opioids are one of those categories that he is taught about, and what he's to do in response to those. I think he did discuss his experience of administering Narcan himself and witnessing other officers also administer Narcan and the effects of that afterwards.
But does he have technically, under the law, the expertise to specifically identify the drug of impairment if he's not a DRE?
So I would say that
And aren't you required to do that to have sufficiency when you don't have medical testing?
well, so he, all I can say is that he was able to testify to what his training experience was and what he noticed of Mr. Petersen at the time of this incident. and what he believed that to be. And the state did not only have this trooper testify, the state also had this EMT paramedic who did have the requisite, state's position as the requisite training to be able to testify to what his ultimate conclusion was in this case.
And one last question on that, Brian. Same as I asked for the council. Was there any objection at either point to either the trooper or the EMT offering any opinion as to whether or not he was on drugs?
Your Honor, I'm going to be honest, it has been a very long time since I've tried this case, so I do not recall specifically. I do know that we did, if there was an objection, that we overcame the objection, because I do know that the officer and the EMT paramedic was able to testify in that manner. All right, so moving from, we have that first person who did respond to the scene, who was involved in the incident. We have Trooper Eaton, who then testified what he viewed of Mr. Petersen. And this is what he had presented to the jury, that he saw Mr. Petersen was in that frozen position, and he was chewing gum with his eyes open. He was non-responsive to the trooper's questions. He also noted that his skin was bluish and purple and pale, and he noticed that at that point, Mr. Petersen did have constricted pupils as well. At some point during the investigation, Mr. Petersen became completely unresponsive, and Trooper Eaton did testify that he believed, given what he knew in his training experience, that Mr. Petersen was going through an opiate overdose. Now, Trooper Eaton also had the opportunity and did testify that he did speak with Mr. Petersen after Narcan was administered to him, and noticed that he was completely awake, he was completely aware. It was in stark contrast to what he was before, but he was overly concerned with the location of his keys. He was not concerned with the fact that, even though he had said, I might have had a seizure, he was not concerned with his medical health, and the fact that he had just crashed on the side of the highway. Now, Trooper Eaton also spoke with Mr. Petersen again at the hospital and requested a urine sample. And Mr. Petersen's response was to ask the trooper if he had used drugs a few days prior, would that show up in that test? And he ultimately refused any tests by the trooper, but he also refused all medical care or tests at the hospital as well. So, like I indicated, the trooper ultimately believed that Mr. Petersen was overdosing under the influence of opioid in this case while he was operating his vehicle. But then the state did also call Jake Conable, the EMT paramedic, to the stand to testify. Now, he testified that he was the paramedic that had responded, and he also testified, given his training experience, the signs of an opiate or narcotic analgesic overdose, and he indicated that those are pinpoint pupils, decreased respiratory drive, unresponsiveness, unconsciousness. And when he arrived at the scene, he assessed Mr. Petersen for a narcotic analgesic overdose by looking for track marks, pinpoint pupils, decreased respiratory drive, cyanotic skin, and unresponsiveness. And he indicated that Mr. Petersen had all of those symptoms. Now, Mr. Conable testified that he assisted Mr. Petersen with his breathing initially, and then administered Narcan. And he testified that Narcan would only reverse the effects of a narcotic opiate overdose. It would have no effect on an individual who was going through some other medical emergency or a seizure, as Mr. Petersen argued at the trial. Now, Mr. Conable testified that Mr. Petersen, as soon as he was given Narcan, I believe it was a single dose, he immediately responded, he immediately became responsive. His breathing completely normalized. And Mr. Conable testified that during this incident, Mr. Petersen was blue, he had pinpoint pupils, he was non-reactive, he had track marks, decreased respiratory drive, and he was also unresponsive. Mr. Conable testified that given his training experience, Mr. Petersen was not having a seizure, and he did testify to his experience with seizures, but he was overdosing on an opioid. So not only did we have these individuals testify, but we also had the body camera of Trooper Eaton, who we did play that for the jury, and they were able to see Mr. Petersen at the time of this incident and view as he was after the crash when the trooper arrived. So, and that also included Mr. Petersen before and after the administration of Narcan, too. So there was substantial evidence presented by the state that Mr. Petersen was operating his vehicle under the influence of a drug of abuse, specifically an opioid narcotic analgesic, at the time of this incident, and any rational trier of fact would have found that those elements of the offense were met. So the state's requesting that the first and second assignment of error should be denied. I do want to address very briefly the second assignment of error, which is the manifest weight of evidence, and the question is whether the state has met its burden of persuasion in this case. I'm not going to go through all of the facts that I just went through because there's the overlap there. But with a manifest weight challenge, the entire record must be reviewed and credibility of the witnesses evaluated in determining whether the jury clearly lost their way. This is the state's position, the jury did not lose their way. Mr. Petersen, during the trial, did make the argument that he was going through a seizure. He said that at the time to the trooper at the time, that he believed he may have had a seizure, given he had one, I believe, when he was 15 years old. So he makes this argument to the trooper, and then both the trooper and the paramedic both were able to say what their experience was with responding to incidents with individuals who are going through seizures.
Well, is a trooper or an EMT really qualified to know what seizure behavior is?
Well, it depends on their training
Like,
experience.
is it
So-
possible that you could have a seizure at 15 and then not have another one until 15 years later if you had a history of seizures? Do you think the trooper or an EMT are qualified to make that type of decision?
So certainly an EMT paramedic does have the training, but given each of those individual, the officer and this particular EMT paramedic, their particular experience, given that experience and their training, I believe that combined gives them the ability to testify. And I don't know specifically that they addressed that specific question. If an individual had a seizure at 15, could they have a seizure at 50? I think certainly it's plausible, but given the facts of this case and
But
what
the
these
trooper
individuals.
certainly made opinions about what seizure behavior is, like the defendant was supposedly requesting his keys, and this trooper opined that if he was having a seizure, he'd be more concerned with his medical condition.
Well,
Like,
that was
is that
the-
really within the purview of a trooper on that issue?
I think it depends on the experience of the trooper, and also, I'm not certain that there were objections to the questions and answers throughout the trial court when these answers were being elicited.
Couldn't the trooper have obtained a search warrant for a blood draw for the defendant to ensure that there was, been able to present that evidence that he had been impaired by opioids?
Yes, the trooper could have
He
done
could
that.
have enlisted medical care.
Right, yes, but he had requested a urine sample, and Mr. Petersen denied
Refused.
providing it, yes.
But if there's a warrant, he can't refuse, right?
You're correct, Your Honor. He pursued a request for a urine sample instead of a warrant. So it's the state's position that not only did we meet the burden of production, we also met the burden of persuasion in this case, and I would ask that both assignments of error be denied in this case. Thank you.
Thank you.
Your Honor, first, I want to apologize. I stated on the record that there were no witnesses to this driving. That's obviously not correct. I want to retract that, Your Honor, that there was a witness, okay? Your Honor, it's important. I'm just surprised that he was even charged with driving under the influence in this case. The initial charges because of the complete lack of evidence in the case. You know, and during the trial, neither the trooper nor the EMT person, Mr. Conowall, could testify within a reasonable degree of medical certainty that either they couldn't rule out a seizure and they couldn't state with a reasonable degree of medical certainty that he was under the influence of an opioid. Neither one of these witnesses that testified were qualified or could reach that level in their testimony. So again, you know, the jurors lost their way. Now, you know, the problem with that is the jurors maybe didn't understand the standard of proof, level of proof for medical testimony. That's what this was in this case. Medical testimony was proper just through a mere opinion that he was not having a seizure and that he was under the influence of an opioid and had overdosed on opioid. There was no medical aftercare in this, okay, so that would have maybe been determined whether or not, you know, he was either having a seizure or whether he was under the influence of an opioid. That wasn't done. You know, again, like I said, this case, I'm just surprised by the complete lack of evidence. It was based completely on mere opinion. And if you think about this, Your Honors, anybody who could be in an accident, who could be unresponsive, with this lack of evidence could be charged with driving under the influence of some.
Well, there's not a complete lack of evidence. There's the officer of the EMT's testimony that his condition and what he was exhibiting with blue nudge in people was consistent with some an overdose. I mean, it wasn't like they just pulled over and said, gee whiz, we don't know what happened, it must be an overdose. They had testimony that led them to believe that was the case. Whether or not their opinion is sufficient, there's no evidence. There is that evidence that exists.
You're correct, John. There was evidence. I would call that evidence weak evidence that was presented.
Well, but you're saying there's none and there's evidence.
No, and that's, I stand corrected. It was very weak evidence in the trial. And again, I would point to the fact that almost anybody that would have some type of an accident to become unresponsive if there's a lack of tests. That a trooper or an EMT could make the same type of conclusions based upon just mere opinion without a lack of any kind of test to clarify or to indicate that, and also a lack of the medical expertise required to make either one of these diagnoses that somebody's not having a seizure, or they are having a seizure, or they're under the influence of an opioid, or they're not. And that just simply wasn't presented in this case. All the evidence was presented through the testimony of the trooper and the EMT person. That was not presented in this trial, and for those reasons, I would ask the court to reverse.
Counsel, would you like to speak to the issue of the body camera video? Because I don't think you addressed that.
I understand that there was issue with the body cam, and that, some of the conversation with, when the appellant, Mr. Petersen, came out of it, he was out of it. I understand his behavior, and once again, I think that was based just upon opinion again, that somebody exhibiting this type of, behavior is somebody that had to be under the influence of an opioid and could not have suffered a seizure. Once again, I go back to the point that I made, that neither one of these individuals that testified was medically trained to the degree that they could make that determination with a reasonable degree of medical certainty on it. So again, I'm going to ask the court to reverse the conviction in this case. Thank you.
Thank you.
The court will take this matter under advisement and issue a written decision in due course. The clerk of courts will mail you a copy of the decision on the day it's released. Also, the opinions are posted on the Ohio Supreme Court website. Thank you both for your presentations.